Hey everybody, welcome back to the Court of Random Opinion. My name is Lauren Neidigh. We have some documents to go over in the Blake Lively versus Justin Baldoni case. Actually, this is on the Jen Abel versus Stephanie Jones docket. It's relating to the Vanzan motion to compel from the other night. So Justin Baldoni and the Wayfarer parties, Jen Abel being the primary one on this, are trying to get these documents from Vanzan Incorporated, including the subpoena that was sent to Stephanie Jones, which they got all those communications between Justin and the other Wayfarer parties from. Documents pertaining to Vanzan Incorporated that show they're basically a legitimate operation. Good luck with that. Like I said, it's a shell company that Blake and Ryan used to file a sham lawsuit, which we all know. And there was a couple other things as well, I think, including the actual documents that were sent to or from Stephanie Jones. So they're looking for that. Vanzan is fighting back from that. Of course, they don't want to turn over anything, which, I can't imagine that this is not relevant to the case. So if the judge denies this, then I'm even going to have a hard time saying he's not a little off. And, I'm very, very careful with that. So we're just going to have to see how this goes. But let's take a look through their response tonight. It's not going to be a super long stream, guys. I did want to get to it right away, but if we get through this quickly enough, I can get 8 hours of sleep, which is totally never going to happen, but a girl can dream. So, Jess Ricardo, thank you for the $2. Hello, lovelies and lovely Lauren. I love you. I love you too, Jess Ricardo. Thank you very much. I appreciate it. All right, let's get right into it, shall we? We'll read the letter first, and then we'll read the exhibits. 61. Make sure you guys can see this. Okay. Nope. Too big there. No, that's not what I wanted. There we go. That's just right. Okay. Give me one sec, guys. Okay, so let's take a look at this letter. So these lawyers are writing on behalf of Vanzan in response to the motion to compel. The motion appears to be yet another attempt by Abel and the Wayfarer parties to use these legal proceedings to continue their negative media campaign against Blake Lively and her associates. Well, they wouldn't have had to file it if you would just turn over your documents. But the thing is, you don't want to turn them over because this is a fake fucking company. It's a shell company. You're an idiot. I hate these people. I swear to God. In case you guys can't tell, I had my nighttime marijuana before this stream, so we're going to try to get through it quickly, like I said. All right. This time by seeking documents from a third party that Abel already possesses or are irrelevant to any of claims or counterclaims in this litigation. And the only justification Abel offers is the Wayfarer party's time-worn argument that there was something improper with respect to the Doe lawsuit Vanzan filed in New York State Court, which uncovered scathing evidence of Abel and the Wayfarer party's retaliation campaign against Miss Lively. How do you not understand? Like, how are you this fucking dumb? If I were an attorney, I would never write a document like this that made me look this fucking dumb. Of course it was improper. You can't file a lawsuit against John Doe's 1 through 10 when you actually know who John Doe's 1 through 10 are. The only reason you would do that is if you're trying to fly under the radar and do something sketchy. And you cannot do that. People have a right to say, no, this is my private information. You don't have a right to access that, and to have a judge preside over that. And they never had a judge assigned to this case because they did some crazy, weirdo, kind of illegal shit, in my opinion. Depends on who you ask, and maybe it's not technically illegal, but it's totally improper and unethical, in my opinion, to get these communications. I'm reading this right now, and I'm like, this is blowing my mind. The pot's not helping, but yeah. All right. Okay, but Abel offers no legal or factual support for this argument because there is none. What's more, Abel attempts to mislead the court by suggesting that two of the subsets of documents she requests, the subpoena and the corresponding produced documents, are not fully in her possession when she knows they are, and B, that Vanzan has somehow been uncooperative when in truth Abel abandoned the meet and confer process and filed this motion out of the blue after no communications for 3 weeks. Well, we'll just see about that, shall we? So the letter from Blake last night basically said that Blake had turned over a copy of the subpoena But they admitted that like it was missing some attachments, so not all the documents were included. And also Wayfarer explained that they need original copies from both Vanzan and from Stephanie Jones because they need to see the metadata, because they're alleging that this was like a sham action and that the exchange was not proper. So they explained why they need this from those parties specifically. So this is like smoke and mirror shit right here that I'm reading, but okay. This motion should be denied for two principal reasons. One, Abel has already received the only potentially relevant documents. Two, the remaining requests have zero relevancy to any claim or counterclaim in this litigation. How does it not have relevancy? They're claiming that you used a shell company to do some illegal shit. I feel like it's pretty relevant. However, as set forth below, to expedite this litigation and reduce the burden on the court caused by Abel's unnecessary motion practice and abandonment of the meet and confer process, Vanzan will voluntarily agree to produce documents responsive to requests numbers 10 through 11, even though Abel already has them, and to request numbers 1 and 4 based on Abel's narrowed requests as articulated in the motion to the extent described below. Thus, the motion should be denied as moot as to request numbers 1, 4, 10, and 11. As to request number 9, which seeks communication between Vanzan and or its counsel and Stephanie Jones and Jones Works, Abel should obtain those documents directly from Miss Jones. So the thing is, she needs it from both parties. She needs to see the original communications from both parties. Why do you have such a problem with that? You're saying, I'll produce everything else except for this. That's fucking sketchy to me as a layperson, right? Because I'm not a lawyer, but that's fucking sketchy to me. My God. Oh, hey, Cass. What's going on? All right. If you're telling me like, oh, I guess, well, she's being unreasonable, but we'll give it to you anyways, except for this, then you're fucking sketchy. You obviously don't want us to see that for a reason. Like, what the fuck are you doing? As an initial matter, the motion is notable for what Abel omits from it. She fails to inform the court that she abandoned the meet and confer process. Okay, let's see. On May 27th. And they have the emails here, so we'll see it. During that conference, follow-up email, Vanzan highlighted its various objections to the subpoena. Nevertheless, to resolve the dispute without the court's involvement, Vanzan offered to produce 2 of the items that Abel now seeks. Again, not all of them, just 2 of them. Specifically, the Doe subpoena, okay, and the documents produced by Miss Jones in response, numbers 10 and 11. Vanzan confirmed this proposed solution via email on May 30th and offered to further confer. Counsel did not receive a response, even though by that time Abel had already received production of the subpoena and responsive documents over a week before that. 3 weeks later, Abel filed the instant motion without any notice to Vanzan, obscuring the fact that she already had the documents in her possession. Let's see. The footnote says, in light of this, Abel's assertion that she remains in the dark about whether Jones actually produced documents in response to the subpoena, motion at 2, is both shocking and misleading. I disagree. Again, you don't want to show your actual, like, what you actually said to Stephanie Jones, and there's an allegation that you guys were in some sort of weird conspiracy. So how is that misleading? Like, it's an actual claim that's being made. Prove you didn't do it. If this is so preposterous, prove you didn't do it. What's the problem? My God. All right. Further, as a threshold issue, Abel's motion should be denied because Abel fails to demonstrate how the documents are relevant to the claims or counterclaims. Agree to disagree, bitch. I'm really tired. Abel has a far-fetched theory that the documents are relevant to her amended counterclaims. Her amended counterclaims, of course, are currently subject to pending motions to dismiss. So what? You didn't get a stay of discovery, which, if granted, would eliminate the issues in the motion entirely. But Abel's counterclaims are at heart an employment dispute with her former employer, Miss Jones. Her former employer, Miss Jones, who you refused to disclose your communications with. And have nothing to do with Vanzan. Well, nothing has anything to do with Vanzan, you fucking dumbass. Oh my God. That's not an argument you want to make, is it? Who broke their contract with Vanzan the way you guys allege in the lawsuit? Fucking no one. Oh my God, I'm so tired. The claim, sorry, when I say tired, I mean sleepy. Like, I'm actually just sleepy. So I'm not complaining about the reading, because obviously I wouldn't be here doing it if I didn't want to do it. I'm just saying, because I know people were getting upset about that the other day when people were saying they were tired. No, I'm physically tired. Mentally and emotionally, I'm right here. So the claims arise from events Abel says occurred when she was terminated and her cell phone was obtained by her employer in August 2024. Events in which Vanzan is not alleged to have been involved in any way. What? The claims arise from events Abel says occurred when she was terminated, and her cell phone was obtained by her employer, events in which Vanzan is not alleged to have been involved in any way. In what way were you not involved when you got the, oh my God, you got the communications from that event? What are you talking about? Oh my, okay. Moreover, the request also seek documents that are more appropriately sought from Plaintiff Jones or other parties to litigation. And like I said before, guys, there's a reason they seek them from both Stephanie Jones and Vanzan. So they're willfully ignoring that here. Let's see. They received the subpoena from Miss Lively, blah, blah, blah. Again, that's irrelevant because they're trying to see the metadata and the original copies and what was actually exchanged between them and Stephanie Jones, because the allegation is actually at one point that Stephanie Jones disclosed the text messages that she was meant to keep private from her former client, very freshly former client, Wayfarer. And she instead disclosed that to Leslie Sloan, the PR person for Blake Lively. So it's pretty fucking relevant if you ask me. But ultimately, the motion is consistent with Abel and her counsel's pattern of using the court's docket to advance public relations narrative in the media. Well, what would you know? Your company's a broom closet, you fucking dumbass. If that were not their goal, Abel would have continued the meet and confer process, or at least responded to Vanzan's May 30th email and informed the court she in fact possesses the information she now seeks. Well, I also don't like to email back and forth with inanimate objects, so maybe I wouldn't have responded either. I don't know. Why don't we just, before I explode, go to the emails? Give me 1 second, guys. I need some water. Yes, the PR narrative is exhausted. Every time anything happens, they're like, it's a PR stunt, Judge, it's a PR stunt, Judge, help us, Judge. Yeah, okay, honey, if you didn't do anything wrong, you wouldn't have to do that every week, would you? No. All right. So these emails, we have to scroll kind of up to see them. There are disclosures down here, but they don't really say anything, so we're not going to go over those. We're just going to go through these emails. So the first email here said it's from Jason Sunshine Esquire on the 22nd. Says, yes, that works for us. Thanks. Great. Thanks. Please send us an invite when you have a chance. So they're just talking about when they're meeting and conferring or whatever. This one on May 27th says, hi, Maggie/John. I'm writing to recap the meet and confer call this afternoon concerning the subpoenas served on on Vanzan and Mannett with respect to the Vanzan subpoena. So that's kind of interesting. They served a subpoena on Mannett as well, the law firm where Samantha Katz, who wrote up that Vanzan subpoena, works. They're a firm representing Blake Lively in this case. We propose the following: withdrawing requests numbers 2 and 3 and 5 to 8. Narrowing request 4 to seek only the identities of Vanzan's shareholders and not the other information. Narrowing request 9 to seek only communications between Vanzan and or its counsel and Stephanie Jones and Jonesworks and or their counsel. Narrowing request number 10 to encompass only the subpoena served on Jonesworks/Stephanie Jones. And narrowing request number 11 to encompass only documents produced pursuant to the subpoena served on Jonesworks/Stephanie Jones. Okay. We indicated that if the parties can agree on the foregoing, Ms. Abel would be willing to withdraw the Mannett subpoena entirely. So she's saying, I will no longer subpoena the law firm if you just give me what we're asking for right here, which seems pretty reasonable to me. You indicated that you intended to confer with your client. Oh, good Lord. Okay. There were 2 more general concerns you raised involving 1 burden and 2 privilege. As for burden, we do not anticipate that any of the foregoing requests would impose an undue burden on Vanzan, given the limited universe of information sought, and the fact that Vanzan has done nothing but order a piece of furniture in the last 700 years. What the fuck? Okay, I need to calm down. It's bedtime, guys. Undue burden. That's cute. There's only been one burden to serve the subpoena on Stephanie Jones. Ugh. Okay, it's not like you have to go through hundreds of documents. All you've done in the last 10 years is serve a subpoena on Stephanie Jones. You fucking idiot. Okay. As for privilege, we do not anticipate that any of the requests will implicate privileged materials. What privileged materials? If that is wrong, Vanzan must simply produce a privilege log in lieu of any allegedly privileged documents. Ooh, that'll look cute. Okay. What is your availability towards the end of this week to resume our meet and confer on the foregoing? And that was on the 27th. So what do they say here? On the 30th, they respond, and this is the last email in the series here. Jason, who is the lawyer we just heard from. One second. Lauren is so spicy to like. Lauren is tired of their bullshit, okay? And Lauren wants to go to bed, but Lauren's going to read this shit anyways. I don't know why I'm talking about myself in the third person so much, but I am very, very tired of these people's fucking bullshit. All right. Let's see. Jason. I'll try to be nicer, guys. Hold on. Jason. We appreciate your offer to withdraw certain requests from the Vanzan subpoena and narrow the remaining requests as you describe in items 1 through 5 below. However, we do not agree that your email provides an accurate or complete recap of our nearly hour-long meet and confer. An hour-long talking to you? Fuck. I mean, we do not think it is helpful to exhaustively to recite every part of our discussion. However, we want to respond to several points. We hope that this exchange will demonstrate a way forward. You began the meet and confer by clarifying what Ms. Abel actually seeks in these 2 subpoenas. You stated that the materials that Ms. Abel seeks from Manet are all subsumed by the subpoena to Vanzan, and therefore that the subpoena to Manet may be unnecessary and you may withdraw it. We agree that it would be appropriate to withdraw the subpoena to Manet for the reasons we set forth in our objections and prior email correspondence. We urge you to do so. As we noted in our objections and prior email correspondence, the requests in the subpoenas are overbroad and expansive. How can it be overbroad? There's like, oh my God, there's like 1 inch worth of documents relating to your company in the universe. How can anything be overbroad? Okay. However, you explained that what Ms. Abel hopes to receive in litigation is information about the ownership of Vanzan, communications between Vanzan and third parties relating to the Doe litigation filed in New York State Court, and a copy of the subpoena issued in the Doe litigation and the documents produced in response. As if we don't know what that is. As a threshold matter, and we discussed this at length during our meet and confer, we do not believe that the materials you are seeking from Vanzan and Manet are relevant to the underlying employment and contractual claims in the Jones versus Abel litigation. Oh my God. So he says, you're not going to sleep for 8 hours. You've got too much anger and adrenaline. No, you're right. I give it 4. I give it 4. But we're going to try to get through this anyways. Okay. Thus, even if Ms. Abel can demonstrate the relevance of these documents, they are more appropriately sought the actual parties to this dispute. Somebody forgot how to type. They are more appropriately sought, I think, from the actual parties. Don't confuse me like this, right? Learn how to type. Counsel for Ms. Abel stated that you would be willing to withdraw the subpoena in a minute. I think I read that already, didn't I? No, we're going to read it again anyways. And the remaining request of Vanzan, if Vanzan would be willing to produce a copy of the subpoena issued in the Doe litigation and the documents produced in response. We understand that you believe it would be helpful for Vanzan to produce the material so that you can resolve your concerns about whether any subpoenas and productions you received are accurate. As we said during the meet and confer, we will discuss this potential resolution with our client. I'm trying to talk in a manner that's like the human manifestation of elevator music, and it's not working for me. We would expect the Doe subpoena and documents to have been produced by the Jones parties. However, we have not received confirmation that Miss Abel sought or received the documents you are now seeking through third-party discovery. Well, the thing is, they want it from you and her for a specific purpose, which you are aware of, no doubt, because of your hour-long meet and confer that you keep complaining about. So why don't you just turn over the fucking documents? During the meet and confer, you expressed that you were unable to confirm whether you have received any of the Doe subpoena and produced documents due to the operative protective order in the Lively litigation. You offered to review that protective order and determine what information you can disclose regarding your receipt of those documents, so you can confirm to us whether you have already received the subpoena and produced documents. Of course, we would be willing to enter into an agreement that would protect that information, including agreeing to the terms and conditions set forth in the protective order. We reiterate our request that you confirm whether Ms. Abel has received the Doe subpoena and responsive documents from the parties, and if not, the status of that discovery. But that doesn't have anything to do with what they're asking you for, because they need to see exactly what you have, because they're alleging that this was some conspiracy and a lot of shit went on behind the scenes. So you need to produce what you got. They're not asking for your stupid British furniture receipts. So why don't you just turn over everything else you've ever done in the history of your company and we'll be good. Because all they've done is subpoena someone without notifying them. Anyways, assuming Miss Abel withdraws the other requests in both subpoenas, then we are willing to address your concerns regarding accuracy and either confirm the accuracy or produce the documents consisting of the Doe litigation subpoena and produce documents. We believe this would be a satisfactory resolution. We are available to confer further Monday or another day next week. Please let us know your availability to discuss. Best, Maggie. Okay, so they're saying that this was the last correspondence, basically, or they're at least implying. You're scaring me, Lauren. Calm down, my love. I can't. Okay. So they're saying this was the last correspondence. Whether or not that's true, I don't know. I'm certain that based on these emails, that was the last time they met and conferred. But I don't know if anyone ever responded to this email and tried to get more information. I really can't say. So we're going to have to wait for a response from them and see. Honestly, the way they paint it out, as always, it looks kind of bad because it's like, well, they should have continued doing the meet and confer process before they brought it to the judge. But at the same time, we know them to not be a totally reliable source of information, especially because these are the lawyers not representing Blake Lively, but Blake Lively's shell company. So, whatever. All right, guys. Cassidy, I hope you're feeling better. No, the British furniture receipts. Dude, that's all I got. I hope you're feeling better, Cassidy. Thanks for stopping in. All right, let me check these out. Rhonda Rowland, thank you for becoming a new member. I appreciate you. Vilo90, thank you very much for being a member for 3 months. You tell him, Lauren. I like your dog in the costume there. That's cute. Just Ricardo, you know I hate these words. Moistly yummy. I love this chat. Yikes. I can't believe I said that. Just Ricardo, thank you again for the 2 hits bong for Lauren. Join me. Yeah, hit the bongs, bro. Hit the bongs. It makes me feel better. All right, guys. That is all I got from the documents tonight. Like I said, there was some more stuff down at the bottom, and it was like responses to interrogatories, but there wasn't much interesting there because most of them were just like, we're not going to answer this, basically, which is what we've seen with a lot of these interrogatories. So, all right. Everybody, I will see you tomorrow. And as far as the James Vituska stuff, I haven't seen anything on the official docket yet. Personally, I know I've seen a couple of people say that, you know, they have sources that's telling them this happened. I don't have sources like that who are telling me any sort of inside information about what's going to happen on the docket. So like personally, I don't talk about it until it comes out on Pacer or Court Listener or whatever. So I'm not going to say too much about that right now. I'm not saying it's not true. It's just that I don't have these sources, so I don't feel comfortable discussing it too much. Not that you shouldn't, you know, talk about it, because I read about it and I listen to it, but I'm not going to talk about it too much and my opinions on that until it hits the docket. So we'll see. All right, guys. James is dozed off, but woke up to Lauren yelling. That's a horror that many women have faced. No, I'm just kidding. I'm just kidding. I'm totally kidding. I don't yell at people. Let's see. Helene, thank you for the 50. The stream is hilarious. Love you, Lauren. Some Pacer bucks for you. Thank you very much. I will definitely be putting that towards my quarterly Pacer bill. So, all right. Thanks, everybody. What do you think about Lyman giving Blake another chance not to dismiss Jed Wallace from the lawsuit? Well, he's allowing Blake to write a 2-page letter explaining something that he's kind of on the fence on, but then he's also allowing Jed a set time frame to respond with 2 pages a week after that. So like he's letting them go back and forth on the issue. So that's not something I'm really too concerned about. I think a lot of people didn't realize that Jed is also getting a chance to say like, this is why this should be dismissed again, and to reaffirm that. So, all right, guys, I appreciate it. And I will talk to you all tomorrow. So thanks, everybody. Bye.